Okay, good afternoon and welcome to this afternoon's presentation. My name's Zoe Adams and I'm going to be talking today on the topic of the treatment of trusts in property settlement. A little bit about myself by way of very brief introduction. I've been practicing in family law for over 10 years and I'm an associate here at Lynch. The firm itself has been established for more than 24 years and we have 11 specialised family lawyers. We provide private client representation only, and as is the case with any legal advice, it is confidential and professional. We also offer a fixed cost initial consultation. So without further introduction, straight into the topic of trusts and how they are determined or are treated in family law property settlements. I guess there's a distinction in relation to the way trusts are generally used, which is to protect property. But in the case of family law property settlements, they can be considered property and divided between former spouses. It is a myth that the assets of a discretionary trust will be protected in the event that a trustee or beneficiary separates from their spouse, and it is considered on a case-by-case basis. So we will go through some case examples through today's webinar. By way of overview as to what we're going to be discussing today, it is specifically a webinar in relation to discretionary trusts and how they are treated in the four-step process in property settlement. So for that reason, we are going to talk about what is that four-step process to have some understanding as to when we talk about a trust being treated as property, what realistically that means. There will be some case studies, as I've mentioned, and we will also talk about what powers the courts have when they are dealing with trusts and what can be done, I guess, most importantly from an accountant's point of view, if that's the audience today, what can be done to remove a trust from the court's reach. So discretionary trusts, these are things that as accountants, I'm sure that you're all aware of. They're generally used to minimise tax and or protect assets. They involve a settlor, that is the person who establishes the trust, a trustee. Now this can be either a person or a company. The trustee is the person who has ownership over the trust. The beneficiaries who have a equitable interest in the trust assets, and the appointer or guardian who is responsible for removing and appointing the trustee. So in terms of the role of the trustee primarily, they are the owner of the trust property and they have an absolute discretion to apply the income or capital of the trust for the beneficiaries. A person cannot be trustee for themselves alone, and the beneficiaries have a right to due consideration and proper administration of the trust. I just wanted to briefly touch upon a couple of other trusts that aren't established by way of trustee, but which we often will encounter in family law in particular. One is a constructive trust and the other is an implied trust. And as noted on the slides, they arise by operation of the law. Effectively, a constructive trust is where a legal owner is found to hold property on trust for another arising from a common intention, or there's no common intention, but it would be unconscionable for a legal owner to deny others a beneficial interest. The most common example we see of this in family law is where there is, for example, a farming property which is held by either the husband or wife's parents, and there is some discussions, promises made in relation to that property, but which ultimately remains owned by those parents. So that's often a case that is run in the family court, and I thought it may be applicable that there'd be situations similarly arising in your area of work as well. An implied trust, this is where one person acquires a property in the name of another, but there's no intention to gift. So we often see this in family law in terms of post-separation acquisition of property in another's name. So say, for example, the husband and wife have separated and the wife wants to purchase property but thinks that by putting it in someone else's name, it might be outside the reach of the husband. So she might do this by way of putting it in her parents' name, her new boyfriend's name, something of that description. The court can find that there is an implied trust and that it is in fact property of the wife. So that's just what I want to briefly touch upon in terms of trusts arising by operation of the law, as I thought might be of interest to today's audience. The balance of the webinar will be specifically as it relates to discretionary trusts. In terms of considering the four-step process at the outset so that you can consider the trusts in the context of the court's determination, we wanted to start by, I guess, outlining that the four-step process is only undertaken once the court has determined that it is just and equitable to alter parties' interests in property. So once that determination has occurred, the four-step process will be as follows. The first step is the identification and valuation of the property of the parties. So firstly, in terms of the identification and value of the property, it is as at the date of settlement, generally speaking. So it's not as at the date of separation or some other date that the parties might think in terms of what they've agreed upon. It will be as at the date of settlement. This is particularly relevant not only in relation to the identity of the property, but also the value, because we can see changes in value as time progresses from the date of separation until the date of settlement itself. The second step is where the court considers the contributions of the parties, including the direct and indirect contributions towards the acquisition, conservation and improvement of any property, and the non-financial contributions of each party, and the contribution made to the welfare of the family and any children of the relationship. So the financial contributions are normally a little bit more readily identifiable than those other types of contributions. So they are things like income and other windfall financial gains, whether it be by inheritance, personal injuries claim, gift, and so on. Lottery wins are always exciting, but very frequently occur. Non-financial contributions, which is generally, again, a little bit distinct. Sometimes there's a bit of overlap or confusion in relation to non-financial contributions and those as homemaker and parent. But non-financial contributions are typically those where it might be that there's been some labour undertaken on a property which has improved its value. So particularly if you see your tradies out there renovating bathrooms and the like. The third contribution, type of contribution, homemaker and parent. Again, most people who have children well and truly know what this is about. It's about things like doing the dishes, doing the laundry, mopping the floors, reading bed stories to the kids, taking them to and from school and so on. So they all are recognised by the court as contributions. The third step is identifying and assessing the future needs factors, which are identified in section 75(2) of the Family Law Act, which applies to married couples, or section 90 SF subsection 3 as it relates to de facto couples. So they are the same factors, they're just set out in different sections depending upon whether it's a married relationship or a de facto relationship. Some of the most pertinent factors we've just set out in the next couple of slides. The age and health of the parties, resources and employment capacity, which includes income, property and financial resources of each of the spouses. Obviously that text has been emphasised in the context of trusts, and we'll come back to why that is when we deal with some of the case studies. There's also a consideration in relation to whether a party has the care or control of a child under 18, necessary commitments and responsibility to support others, the appropriate standings of living, and the next slide sets out some, again, relevant factors as it may particularly relate to trusts as well. So contributions to income and earning capacity made by either party to the income and earning capacity of the other, the length of the relationship and the effect of the relationship on earning capacity. Sometimes there's a slightly different approach taken to trust property depending upon when the trust was established. And so again, we'll deal with that in the case studies as well. Financial circumstances of cohabitation, if a party is cohabiting with another person, that is in the context of post-separation circumstances, and the court must consider the financial circumstances of that cohabitation. Again, this is particularly relevant where we might be dealing with trusts where there is, for example, either a discretionary trust or, as I've mentioned earlier, it could be by implied trust that has arisen after the date of separation. The court also has a discretion to consider other facts and circumstances that the justice of the case requires. And then we get to step 4, which is what is just and equitable in all of the circumstances. So just to provide an overview in relation to how that process might work by way of illustration, after step 1, you effectively have a balance sheet. That will have a list of all of the assets, superannuation and liabilities as at the date of settlement, and the value will be as at the date of settlement. Obviously, sometimes the court's asked to make findings about those matters, and particularly as it relates to trusts. The second and third step is where the courts, you would have probably heard about percentage adjustments. So people talk about, is it a 50-50, 60-40, 70-30 case? So steps 2 and 3 are really about applying those percentage adjustments to the particular case before it. But the final step is taking a step back and assessing how that percentage adjustment is going to be applied to the property of these parties. So this becomes particularly important in trust cases. In terms of the case studies that we've seen, one of the approaches that is often taken by a court is that they might determine that the property of the trust is in fact property of the parties, but they may then decline to actually make orders specifically as it relates to the property of the trust, and therefore enable the trustee a discretion as to the manner in which they're going to effect or implement the orders. So again, there will be a case study about that, which we will go through shortly. I guess really for the purposes of today's webinar, it's a focus on what is property. Easy identification of property is things like real property, motor vehicles, savings, superannuation, other types of investments, furniture and contents, all of that kind of tangible stuff. And then what's more hard is when a court's asked to determine that the property of a trust is in fact the property of the parties. I guess there's a little bit of a distinction here in relation to how the court can approach a determination where one party is seeking that the property of the trust be considered the property of the parties. The court otherwise has a discretion to take it into account as an adjustment factor or a financial resource of a party. So again, that determination is really significant because if it's property of the parties, the court can in fact make orders dividing it between the two spouses. If it's considered a financial resource, that means the court doesn't have the same level of discretion to apply in respect of the orders it would make in relation to the trust property. In determining whether the property of the trust will be considered property of the parties, one of the key questions for the court to consider is control. So is the trust the alter ego of a party? Does one party indirectly control the trust through a puppet trustee and or appointer? Is the trust a sham? In terms of those particular terminologies, they've just arisen from some of the case law. So we go through more specific examples in relation to what you would consider in regards to the trust that you might be dealing with at any point in time. I guess first and foremost, when you're asked to consider whether the property of the trust should be the property of the parties, you need to have a better understanding about how the trust has been established and operated. So really, part of the obligations of parties in a property settlement is to make full and frank disclosure, and that includes if they have an interest in a discretionary trust. The documents that need to be produced are things like the trust deed and any variations to the trust deed, company constitution if there's a corporate trustee or beneficiary, financial statements and tax returns, and minutes of meeting. We also look at a number of other documents depending upon what those source documents or what you might call the preliminary documents disclose, but that very much is considered on a case-by-case basis. So, for example, there might be loans as between the trust and other parties, and you'd want disclosure in relation to the arrangements that exist in that regard. These are the types of things that the courts have considered in regards to determining who has control of the trust. Does one of the spouses have the sole power to appoint or remove a trustee or change the beneficiary? Is the trustee, whether it's a party, that is a spouse or a company, completely controlled by one of the spouses? Is a spouse or company controlled by a spouse, a beneficiary of the trust? So effectively, that's just the same question being asked as to whether it's sometimes a spouse might only be a trustee or might only be a beneficiary. So the same question would be asked there. Does one of the spouses receive or can receive the majority of the benefits of the trust? Looking at the trust deeds and other documents carefully. So we'll talk about that final statement on that slide in a bit more detail with reference to the cases, which is really looking beyond the documents, because often what happens with family law situations that arise is that there might be a trust deed where the trustee does have certain powers which they've either elected not to exercise, and or there could be other powers being exercised which are actually outside the trust deed as well. So it is important to look at the trust deed in the first instance, and particular the provisions relating to the appointer, the types and classes of beneficiaries, and the trustee's powers. But it's also important to look beyond the documents and consider what has in fact occurred. Bit of a checklist there. This is probably one of the most useful parts of the slides for accountants moving forward, I expect, in terms of wanting to provide some or turn their mind to the preliminary assessment as to whether the property of the trust might be considered property for the purposes of property settlement. Who is the trustee and what are their powers? Who is the appointor? Who are the beneficiaries? Who has received distributions in the past and who is receiving distributions now? That's particularly relevant if there is obviously a significant change at the time that the marriage either declines or in fact at the time of separation. Have there been restructures or amendments to the trust deed, and when did these occur? The leading case is Kennan and Spry, and I'm going to go into some detail about that because I think it's particularly helpful in terms of those types of factors that we need to consider. When were the assets of the trust purchased, before or during the relationship? How were the assets in the trust acquired and financed? So that's particularly so if it's a case, for example, where the former matrimonial home might, for example, be collateral security for the property of the trust. The relationship between individuals as defined in the trust deed. Again, it's not uncommon in a family law situation to see either the husband or the wife has their siblings, parents, or business partners as part of the family trusts, or sorry, the discretionary trust structure. The benefits derived from the trust by the parties, such as drawings, loans, use of motor vehicle, contributions by the parties to the property of the trust. Again, contributions in the sense of what is prescribed under the Family Law Act. So those contributions can be not just financial and non-financial contributions, but also homemaking and parenting contributions as well. If the appointer or trustee is not a party to the marriage or de facto relationship, the degree of influence that either or both of the parties have over that person or entity. And we're going to consider a case of Romano and June, which particularly goes to that point. So I've chosen to go to the leading case in relation to trust because there was a lot of case law prior to 2008 where there really wasn't necessarily a unified approach being taken by the family law courts in relation to the treatment of trust property. But since 2008 in the decision of Kennan and Spry, there is a lot more clarity and certainty in relation to what a court will do in relation to property of a discretionary trust. So I've just noted there, this is a High Court decision in 2008, and to really give consideration as to the findings that were ultimately made by the High Court, I think it's important to consider the context or background, and that is this. The husband, who himself was a lawyer and no doubt thought that establishing a trust was a great way to avoid a claim by his wife, he was both the settlor and trustee of a discretionary trust. Himself, his siblings, and his and their issue and spouses of his siblings and himself are all considered beneficiaries of the trust. He varied the trustee to include himself as a beneficiary and appointed his wife as a trustee on his death or resignation. In 1998, which is effectively 3 years prior to separation, but the marriage was in trouble at that time, he made a further variation to the trust, nominating his 2 daughters as the trustee in the event of his death or resignation, and excluded himself and the wife as beneficiaries. As the case transpires, we learn that this was, of course, done without the wife's knowledge or consent, which is also something I think that is particularly important to the findings that this court ultimately made. The husband and wife separate in October 2001, and in January 2002 he establishes trusts for his, I think, 4 children, and he is the trustee of all of those trusts. The husband distributes the capital and income of the trust evenly between the children's trusts. And I guess what's important, you'll see on the next slide, but effectively he amends those trust deeds in May 2002, when I think it's the month earlier that in fact the wife has commenced property settlement proceedings. So I think he did start to get a bit nervous or a bit worried about what was going to happen, because he did decide to appoint someone else as well as himself as trustee. And that's right, yeah, the following slide confirms in April 2002, she makes an application to the family court seeking orders that effectively set aside the distributions that have been made, the variation to the trust deed that was undertaken in 1998, and the establishment of the children's trusts. I guess it's important to note at this point, a lot of the cases that we encounter dealing with family trusts also have an aspect which us lawyers call 106B, which is the Family Law Act provision. It is set out later in these slides, but ultimately it's about setting aside transactions that parties have undertaken with the intent to defeat another's claim. So you really do see that as being coupled with property of the trust, firstly being determined as property of the parties, and for that reason distributing it to someone else was designed or intended to defeat the other spouse's claim. So in the first instance judgment in the family court, the 1998 variation to the deed was set aside, and the judge basically made a finding that the wife did not need to pursue her application to set aside the establishment of the children's trust, which I do think would have been a difficult case in any event, but because he ultimately determined, or His Honour I should more correctly say, that the distribution of the capital and income to the children's trust was set aside, with the effect being to return the capital and income to the trust. And in effect, the returned capital and income is then treated as property between the husband and wife. I think the reason why I've framed it in that way at that number 4 on the slides is to go back to a comment I made earlier, which is, whilst the court often makes findings that the property of the trust is in fact property of the husband and wife, what might then happen is they say, for example, okay, the property of the trust is $500,000 and the husband needs to make a payment to the wife of $250,000. Rather than it being compelled upon the husband as trustee and or in terms of any particular property of the trust being utilised to make that payment, it's within the discretion of the husband as to how he will give effect to that judgment. Continuing on, the High Court effectively considered the terms of the trust deed and also considered sorry, I've just jumped ahead on the slides there, also considered the findings made by the primary judge that the wife did not know that the husband had varied the trust deed, and also the judge made a finding that he didn't accept that there was any agreement between the husband and wife that the husband's assets were to go to the children, which is what the husband's case was. The assets of the trust, coupled with the husband's power to appoint them to his wife and her right to due consideration, are property of the parties for the purposes of the Family Law Act. So I've just reiterated that really, and then referred to the principle that now really guides us as family law practitioners, which is the question whether the property of the trust is in reality the property of the parties or one of them is a matter dependent upon the facts and circumstances of each particular case, including the terms of the relevant trustee. So as I said, this saw a real shift and people really starting to understand that ultimately the property of a discretionary trust was in the firing line, so to speak, in regards to family law property settlements. I've just referred to this other case of Galvin and Galvin because it actually does include, in my view, a slight distinction in relation to how the court may treat different transactions at different points in time associated with a trust and its property. And I also thought, given the audience is accountants today, that it was important to make comment or observe that the judgment says it is obvious that what the husband was trying to do was basically make provision for his 2 children from his previous marriage, and there's nothing wrong with that as such. However, I'm satisfied that in pursuit of that objective, he set out to and did apply property which might have been applied for the benefit of both him and his wife in ways which were designed to make her, to remove her from making any claim against it. He sought advice from his accountant about that, and his dealings after that point followed a pattern which was consistent with a desire to achieve that objective. So I thought that that was particularly relevant in terms of, as I say, the audience today, and particularly what I refer to, and I'm not suggesting by any means here that the accountant prepared the trust deed, but you will see that what the husband intended to do wasn't in fact what he did because there was an error in the trust deed. Effectively, the parties were married in 2000. The trust was established in 2006. The corporate trustee, the husband's the sole director and shareholder of that company, and the specified beneficiaries are the husband and the 2 children from his first marriage. What I said earlier is what is not most important, but is particularly important in this case. The general beneficiaries included a class of spouse. It is clear that based on the husband's evidence that this was an error in the trust deed, and a very costly mistake at that. In terms of, as it relates to the trust property in this case, there really was, at the time of the judgment, 2 distributions that are being made by the trust in the period around and or about separation that the wife was seeking to be treated as property of the parties by way of seeking orders that effectively the distributions to others would be set aside. So the first transaction was in relation to the property of, the N Street property, which was sold in July 2009. The parties had separated at that time, and the sale proceeds were distributed to the husband's son. The husband commenced family court proceedings in 2010, and the F Street property is then sold in May 2012. The sale proceeds are distributed almost evenly between the husband and his 2 children. The wife sought that both distributions from the trust be set aside. It's interesting to read this case if there's, someone who's got a particular interest in it, we can certainly forward the case, because ultimately the judge determined, for reasons which are not necessarily all that clear, that the July 2009 distribution wasn't going to be set aside, but the May 2012 distribution was to be set aside. Both, as I said, post-separation, both in some respects could be considered intended to defeat the wife's claim, but ultimately the judge only set aside one of those transactions. So as I said, it's interesting, but I also think that it's helpful if we find ourselves in one of these situations, that there is a discretion there in relation to the way the judge has dealt with those different transactions. This case is probably the most controversial case, I think, for accountants. I really like it because it's a decision that's made here in Brisbane by one of the family court judges, Justice Forrest, and it really, I guess, would make people a bit nervous in terms of the findings that he ultimately made in determining that the property of the trust was property of the parties. The husband is one of the directors of the trustee company, however, is not and has never been a shareholder. He's a capital and income beneficiary. And as the husband's spouse, again, just going back to often these trust deeds are drafted such that spouse is a class of beneficiary. The wife is also an income beneficiary. The assets of the trust have been acquired by or through the efforts of the husband before, during and since the marriage to the wife. And the husband regarded and treated the trust and its assets as his, utilised to his own benefit and the benefit of others such as family and friends. The judge made a finding that it was intentional on the husband's part that he has never been put in a position of actual legal control of the trust by making himself the appointer and or sole trustee and or sole director / shareholder of the trustee company. His Honour basically said he really didn't need to make a finding as to why the husband did that, but he did consider it intentional on his behalf. I've got a couple of the specific quotes of His Honour's judgment. It's absolutely clear that the husband actually controls the A trust as a matter of fact, as opposed to a matter of law. I'm satisfied that if the husband wanted to, he could cause the trustee to be replaced. And you'll see his comment here, which is it's the mother and the sister who had that power, I think, as the appointors of the trust to replace the trustee. And the decision was that the net assets of the trust, coupled with the husband's actual control, as opposed to, that is a finding that the judge made on the basis of fact rather than law, that would allow him to cause those assets to be appointed to himself or his wife, along with his or her right to due consideration, constitute property of the parties. So I guess it really just highlights that this was a case where the husband had intentionally attempted to relinquish some of those aspects of control, and the judge nevertheless made a finding that really, because of the level of influence that he had over the appointor, and coupled with the judge's findings in relation to the manner in which the husband had treated the property of the trust, that it was in fact property of the parties. Okay. So then there's just the comment, and I think that Romano and June really does highlight this, which is every case is judged on its own individual facts and circumstances. I think that there's some unreported decisions, which unfortunately I haven't made their way into these slides for obvious reasons, but for example, where the court has made a finding that because there is a clear pattern, despite it not being a unit trust, for example, but a clear pattern that income and capital of a certain trust was distributed to the husband every year 1/3. So the husband and his two siblings, they each received 1/3 of the capital and income of the trust. And it was clear on that basis that the court made a determination that in fact 1/3 of the trust property was in fact available as property of the parties. So I do think that that was a case again, which is really interesting because it wasn't about the husband having control, and it wasn't about there being any other legal basis upon which really that finding could be made other than that pattern of conduct. So then in terms of if the property is in fact considered the property of the trust, that is considered property of the parties, what is the powers of the court can be exercised? I think again, what's quite confronting is Section 90AC of the Family Law Act, which effectively says that basically this overrides this section of the Family Law Act overrides anything else in any contrary law in the Commonwealth, states or territories, or anything in a trustee or any other instrument. And that's particularly important where I've referred to there 106B of the Family Law Act, where they can set aside transactions that would defeat a person's property settlement entitlement. So I think that that's particularly important in terms of the two powers really going hand in hand. Again, there's a specific section that does, in the Family Law Act, that does then say that trustees can be appointed or removed by order of the family court. So really, it's a far-reaching power that the court has to deal with the property of the trusts, and particularly to wind back any actions that might have been taken, whether it's a variation of a trust deed, a distribution that is being made, and so on. As a matter of practice, how that works, of course, is that those people affected are then joined as parties to the proceedings, so that they're afforded procedural fairness and given an opportunity to be heard in relation to any determination the court may make which would be prejudicial to them. Protecting the assets of the trust, can it be done? Pessimist to me says no, it can't be done, but there is, I guess, some scope in terms of the discretion of the court for there to be some means by which you might be able to protect the assets of a trust. Relinquish control. Obviously very risky, but also, as the cases have demonstrated, that needs to be a genuine relinquishment of control, and cannot be that despite there being no control, that there isn't still a pattern of a husband and or wife receiving a certain distribution. So I really don't think that that's a safeguard against protecting the assets of the trust. However, it certainly would assist. The more that can be done to effectively really minimise the control aspect, which is key, is what you would need to be doing to minimise that risk. Financial agreement. So financial agreements, also known as prenuptials, can be entered into before or during a relationship, and that might be a means by which you protect the assets of the trust. A whole separate webinar could be given in relation to whether prenuptials actually work, and in particular following a High Court decision, which is only a couple of years old. So I do think that, again, if you were obviously wanting to enter into a financial agreement as a means by which you were protecting the assets of the trust, you'd really be wanting to get some specialised family law advice about how that might work, and particularly the intermingling aspect. I guess this final slide is really just talking about what you might be doing in terms of a situation, rather than this being contested in the court, it more so being a situation where parties have agreed in relation to what's going to occur with their property settlement. There's a number of benefits associated with them obviously documenting that agreement. The first is obviously finality, in the sense of making sure no one can come back and have a second bite at the cherry years later. Some of the other benefits, again, probably relevant, to this audience, is that there's no stamp duty in relation to, or capital gain, there's also, capital gains tax rollover relief as a result of transactions required to give effect to property settlement orders. There's a little bit of a difficulty with that one, and again, I expect accountants are probably more well-versed in this than me, but if it's a resettlement of a trust, those benefits do not apply. The other benefit of having an agreement, particularly if there's self-managed superannuation, is the manner in which you can split that superannuation such that the parties can have a more equitable sharing in regards to their superannuation interests. I think we've come to the end of today's webinar, so I'm hoping that that was of assistance in relation to, as I say, discretionary trusts. In the event there are any questions, I think we've got some means by which we can organise that through the webinar, but I've also invited people, there's an email address there, and we've also got our phone number on the following slide, to make direct contact with me if there's actually a particular fact scenario that they have themselves that they want to discuss. So we're just going to have a look now, I think, to see if there's any. So Australian number. So there is in fact a there's only an Australian number for people to contact us. Sorry, I'm just reading one of the questions that's come through. So it will be on the next slide. And it might even be in publication that you've already received. And again, there's just some information there as well in relation to the first consultation associated with whether the client sees a solicitor associate or an accredited specialist. In terms of those initial consultations, we often do have those in conjunctions with accountants. It's particularly useful with people whose accountants really do manage and run their financial circumstances. So if there is any further questions, as I mentioned, please feel free to contact me directly, and we'll just wrap things up there. Thank you.